The Partnership Act, 1932, an act to define and amend the law relating to partnership. Whereas it is expedient to define and amend the law relating to partnership, it is hereby enacted as follows. Chapter 1 Preliminary 1. Short title: Extent and Commencement. 1. This act may be called Partnership Act, 1932. 2. It extends to the whole of Pakistan. 3. It shall come into force on the first day of October, 1932, except Section 69, which shall come into force on the first day of October, 1933. 2. In this act, unless there is anything repugnant in the subject or context, an act of a firm means any act or omission by all the partners, or by any partner or agent of the firm which gives rise to a right enforceable by or against the firm. B. Business includes every trade, occupation and profession. C. Prescribed means prescribed by rules made under this act. D. Third party, used in relation to a firm or to a partner therein means any person who is not a partner in the firm, and A. Expressions used but not defined in this act and defined in the Contract Act, 1872, shall have the meanings assigned to them in that act. 3. Application of provision of Act 9 of 1972, the unrepealed provisions of the Contract Act, 1872, save insofar as they are inconsistent with the express provisions of this Act, shall continue to apply to firms. Chapter 2 The Nature of Partnership. 4. Definition of partnership: partner, firm, and firm name. Partnership is the relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. Persons who have entered into partnership with one another are called individually partners, and collectively a firm, and the name under which their business is carried on is called the firm name. 5. Partnership not created by status. The relation of partnership arises from contract and not from status, and, in particular, the members of a Hindu undivided family carrying on a family business as such, or a Burmese Buddhist husband and wife carrying on business as such are not partners in such business. 6. Mode of determining existence of partnership. In determining whether a group of persons is or is not a firm, or whether a person is or is not a partner in a firm, regard shall be had to the real relation between the parties, as shown by all relevant facts taken together. Explanation 1. The sharing of profits or of gross returns arising from property by persons holding a joint or common interest in that property does not of itself make such persons partners. Explanation 2. The receipt by a person of a share of the profits of a business, or of a payment contingent upon the earning of profits or varying with the profits earned by a business, does not of itself make him a partner with the persons carrying on the business, and, in particular, the receipt of such share or payment by a lender of money to persons engaged or about to engage in any business. B. By a servant or agent as remuneration. C. By the widow or child of a deceased partner, as annuity, or D. By a previous owner or part owner of the business, as consideration for the sale of the goodwill or share thereof, does not of itself make the receiver a partner with the persons carrying on the business. 6a. Act not to apply to certain relationship. Nothing contained in this act shall apply to a relationship created by any agreement between a banking company and a person or group of persons providing by sharing of profit and losses arising from or relating to the provision by the banking company of finance to such persons or group of persons. Explanation. For the purposes of this section, banking company and finance shall have the same meaning as in the Banking Tribunals Ordinance, 1984, subs. 7. Partnership at will, where no provision is made by contract between the partners for the duration of their partnership, or for the determination of their partnership, the partnership is partnership at will. 8. Particular partnership. A person may become a partner with another person in particular adventures or undertakings. Chapter 3. Relations of partners to one another. 9. General duties of partners. Partners are bound to carry on the business of the firm to the greatest common advantage, to be just and faithful to each other, and to render true accounts and full information of all things affecting the firm to any partner or his legal representative. 10. Duty to indemnify for loss caused by fraud. Every partner shall indemnify the firm for any loss caused to it by his fraud in the conduct of the business of the firm. 11. Determination of rights and duties of partners by contract between the partners. 1. Subject to the provisions of this Act, the mutual rights and duties of the partners of a firm may be determined by contract between the partners, and such contract may be express or may be implied by a course of dealing. Such contract may be varied by consent of all the partners, and such consent may be express or may be implied by a course of dealing. 2. Agreements in restraint of trade, notwithstanding anything contained in Section 27 of the Contract Act, 1872, such contracts may provide that a partner shall not carry on any business other than that of the firm while he is a partner. 12. The conduct of the business, subject to contract between the partners. A. Every partner has a right to take part in the conduct of the business. B. Every partner is bound to attend diligently to his duties in the conduct of the business. C. Any difference arising as to ordinary matters connected with the business may be decided by a majority of the partners, and every partner shall have the right to express his opinion before the matter is decided, but no change may be made in the nature of the business without the consent of all the partners. And D. Every partner has a right to have access to and to inspect and copy any of the books of the firm. 13. Mutual rights and liabilities, subject to contract between the partners. A. A partner is not entitled to receive remuneration for taking part in the conduct of the business. B. The partners are entitled to share equally in the profits earned, and shall contribute equally to the losses sustained by the firm. C. Where a partner is entitled to interest on the capital subscribed by him, such interest shall be payable only out of profits. D. A partner making, for the purposes of the business, any payment or advance beyond the amount of capital he has agreed to subscribe, is entitled to interest thereon at the rate of 6% per annum. A. The firm shall indemnify a partner in respect of payments made and liabilities incurred by him. I. In the ordinary and proper conduct of the business. And E. In doing such act, in an emergency, for the purpose of protecting the firm from loss, as would be done by a person of ordinary prudence, in his own case, under similar circumstances. And F. A partner shall indemnify the firm for any loss caused to it by his willful neglect in the conduct of the business of the firm. 14. The property of the firm, subject to contract between the partners. The property of the firm includes all property and rights and interest in property originally brought into the stock of the firm, or acquired, by purchase or otherwise, by or for the firm, or for the purposes and in the course of the business of the firm, and includes also the goodwill of the business. Unless the contrary intention appears, property and rights and interest in property acquired with money belonging to the firm are deemed to have been acquired for the firm. 15. Application of the property of the firm, subject to contract between the partners. The property of the firm shall be held and used by the partners exclusively for the purposes of the business. 16. Personal profits earned by partners, subject to contract between the partners. If a partner derives any profit for himself from any transaction of the firm, or from the use of the property or business connection of the firm or the firm name, he shall account for that profit and pay it to the firm. B. If a partner carries on any business of the same nature as in competing with that of the firm, he shall account for and pay to the firm all profits made by him in that business. 17. Rights and duties of partners after a change in the firm after the expiry of the term of the firm and where additional undertakings are carried out, subject to contract between the partners. Where a change occurs in the constitution of a firm, the mutual rights and duties of the partners in the reconstituted firm remain the same as they were immediately before the change, as far as may be. B. Where a firm constituted for a fixed term continues to carry on business after the expiry of that term, the mutual rights and duties of the partners remain the same as they were before the expiry, so far as they may be consistent with the incidents of partnership at will. And C. Where a firm constituted to carry out one or more adventures or undertakings carries out other adventures or undertakings, the mutual rights and duties of the partners in respect of the other adventures or undertakings are the same as those in respect of the original adventures or undertakings. Chapter IV. Relations of partners to third parties. 18. Partner to be agent of the firm, subject to the provisions of this Act. A partner is the agent of the firm for the purposes of the business of the firm. 19. Implied authority of partner as agent of the firm. 1. Subject to the provisions of Section 22. The act of a partner which is done to carry on, in the usual way, business of the kind carried on by the firm, binds the firm. The authority of a partner to bind the firm conferred by this section is called his implied authority. 2. In the absence of any usage or custom of trade to the contrary, the implied authority of a partner does not empower him to a. Submit a dispute relating to the business of the firm to arbitration. B. Open a banking account on behalf of the firm in his own name. C. Compromise or relinquish any claim or portion of a claim by the firm. D. Withdraw a suit or proceeding filed on behalf of the firm. A. Admit any liability in a suit or proceeding against the firm. F. Acquire a movable property on behalf of the firm. G. Transfer a movable property belonging to the firm, or H. Enter into partnership on behalf of the firm. 20. Extension and restriction of partners' implied authority. The partners in a firm may, by contract between the partners, extend or restrict the implied authority of any partner. Notwithstanding any such restriction, any act done by a partner on behalf of the firm which falls within his implied authority binds the firm, unless the person with whom he is dealing knows of the restriction or does not know or believe that partner to be a partner. 21. Partner's authority in an emergency. A partner has authority, in an emergency, to do all such acts for the purpose of protecting the firm from loss as would be done by a person of ordinary prudence, in his own case, acting under similar circumstances, and such acts bind the firm. 22. Mode of doing act to bind firm. In order to bind a firm, an act or instrument done or executed by a partner or other person on behalf of the firm shall be done or executed in the firm name, or in any other manner expressing or implying an intention to bind the firm. 23. Effect of admissions by a partner. An admission or representation made by a partner concerning the affairs of the firm is evidence against the firm, if it is made in the ordinary course of business. 24. Effect of notice to acting partner. Notice to a partner who habitually acts in the business of the firm of any matter relating to the affairs of the firm operates as notice to the firm, except in the case of a fraud on the firm committed by or with the consent of that partner. 25. Liability of partner for acts of a partner. Every partner is liable, jointly with all the other partners and also severally, for all acts of the firm done while he is a partner. 26. Liability of the firm for wrongful acts of a partner, where, by the wrongful act or omission of a partner acting in the ordinary course of the business of a firm, or with the authority of his partners, loss or injury is caused to any third party, or any penalty is incurred, the firm is liable therefore to the same extent as the partner. 27. Liability of firm for misapplication by partners, where a partner acting within his apparent authority receives money or property from a third party and misapplies it, or b. A firm in the course of its business receives money or property from a third party, and the money or property is misapplied by any of the partners while it is in the custody of the firm is liable to make good the loss.